Monsieur McGregor.
Against.
Unfortunately, Mr. Steinley, that amendment has failed, 6-4. So that brings us, colleagues, to Clause 11. Shall Clause 11 carry? I assume on division, based on our precedent. Okay, short title and the title, CPC 8 and 9, we're contemplating changes which ultimately didn't come into force. They're inadmissible. So shall the short title carry? On division? Okay, shall the title carry? Oh, shall the preamble carry? On division? Shall the title carry? I'm assuming on division. I'm going to keep moving through this, colleagues, unless you hear differently. Shall the bill as amended carry? On division, I presume. Shall the chair report the bill as amended to the House? I assume on division. And shall the committee order a reprint of the bill as amended for the use of the House at report stage? I assume on division. Okay, colleagues, thank you let me first, on your behalf, thank our officials for being here today and your work in your respective portfolios. Colleagues, I appreciate your work on this committee and the witnesses that have come before the House on this bill. We don't have anything else scheduled today, but go ahead, Mr. Barlow, very quickly.
Thanks, Chair, and just to the committee's indulgence on this bill, and I have spoken to the clerk on this. This was like something I have never experienced at this committee before, and perhaps it's happened at other committees. And I don't mean this as the members of this committee. I think we all get along. We get along very well. But when we were trying to work with potential witnesses to have them come and speak to this bill and really tell their stories about why this industry is important to them, how long they've been going on. It was, and I'm sure all of you had the emails in your offices that your staff had to deal with, which was, in my opinion, quite disgusting with how some of the activists who were pushing for this legislation were treating not only members of Parliament, but certainly the witnesses we had. And we had a number of witnesses that eventually decided not to appear at committee because of the intimidation and the reaction that they were getting from phone calls. A couple of witnesses had to call the RCMP on multiple occasions as a result of protests or intimidation at their farms or at their businesses. And I just want to mention to the committee here that unlike any time that I've seen that we've had witnesses that have refused to attend because of the threats that they were being thrown at them, I guess we'll say, and the harassment that they were having to endure from animal activists, which is really unfortunate, as I think no matter where you stand on an issue, you should have your voice heard and feel free to have that voice heard. And under the House of Commons Procedure and Practice, Section 20, under committees and subsection related to witnesses, it states, and I want to quote this here, witnesses appearing before committees enjoy the same freedom of speech and protection from arrest and molestation as do members of Parliament. At the committee's discretion, witnesses may be allowed to testify in camera when dealing with confidential matters of state or sensitive commercial information. Under special circumstances, witnesses have been permitted to appear anonymously, which, thank you to the clerk, we were able to do. But tampering with a witness or in any way attempting to deter a witness from giving evidence at a committee meeting may constitute a breach of privilege. Similarly, any interference with or threats against witnesses who have already testified may be treated as a breach of privilege by the House. And committee, I just think that we need to set a bit of a precedent here that we always talk out in public how well we work together. And I think we should be sending a message to those who are involved in this industry or may have an opportunity to appear at committee that we are going to have their backs and we are not going to tolerate that kind of harassment and intimidation regardless of where we stand on an issue. Therefore, Mr. Chair, I would like to table this motion, a notice of motion, that the clerk and the analysts be instructed to prepare a brief report outlining the material facts of potential breach of privilege related to the reports of threats, harassment, and intimidation against and the efforts to deter the appearances of potential witnesses and witnesses in relation to the committee study of Bill C-355, an act to prohibit the export of prohibit the export by air of horses for slaughter and to make related amendments to certain acts, and that the chair be instructed to present this report to the House forthwith. Again, colleagues, I was really disappointed to see how other Canadians were treating their friends and neighbors, and certainly our agriculture sector, simply because they didn't support what they were doing for their livelihood. And I think that was something I just wish we would never have to deal with, but it was a matter of fact in this case. And I can honestly tell you we had a number of witnesses who were scared, period, and did not want to appear at this committee to testify about this issue. And I just think that's not right. And if we truly want to go out there in the public all the time and say how well we get along, and this committee, unlike many others, does not have the shenanigans that it does. And again, I'm not saying this was anybody around this table's instigating this type of behavior, because I know that's not true. But I think we should send a message that that's not going to be tolerated, that anyone who feels that they have a position or feels that they feel welcome at this committee, and we will back them up. So I would like to move this motion and have this discussed today while we have an opportunity to do that. Thank you for your indulgence.
Mr. Drouin?
Yeah, I'll just obviously no witnesses should be bullied. I think whether it's on this issue or any other issue. So I would just say, Mr. Barlow, I support what you're saying. Regardless, we know that debates sometimes get passionate, but witnesses should not feel intimidated when they come before our committee, or don't come before a committee because they are being intimidated. But I don't want to specifically tie it to C-355. There has been other studies in front, and as an Ag committee, I think all members of Parliament should encourage witnesses to come forward, and they should feel free to express an opinion without being bullied. I hope we could have dealt with this right away had some witnesses expressed. I'm not aware, but we did have some discussions about a particular witness appearing and not showing their particular face on camera because the witness felt that there could have been some reprisals on that particular witness because of the opinion that they had. So I'm not sure what the report. I'm not sure what the report would say, other than obviously all members of Parliament condone bullying tactics by anyone. I think from all sides we would agree, and I would challenge us as well as members of Parliament not to bully other members of Parliament when we have certain opinions as well. So I don't know what the consequences of that would be.
I'll let the clerk contemplate that. I see Mr. McGregor's hand, and then I see Mr. Patron. We'll let them weigh in, and we can get a sense of where this may go. Go ahead.
Thank you, Chair. Yeah, I mean, it's really important because this committee meeting is happening in public for everyone to understand. Privilege, it's not a term that many people it doesn't mean what many people think it means in a parliamentary context. Privilege is what allows members to be able to do our job on behalf of the people that we serve, but it also is a cone, a very important cone that extends to the witnesses who come before here. And as was demonstrated yesterday in the House, when the Speaker was instructing Mr. Firth when he appeared before the bar, anything that he said while presenting to the House could not be used against him in a court of law or in anything. That's the power of parliamentary privilege, is that even though these proceedings are held in public, nothing on this record could ever be used against someone. And we do that so that we can hear the unvarnished truth from witnesses who can give us their view on sometimes difficult subjects without fear of reprisal. I'm inclined to support this motion because I think it's an important principle to stand on. But I want us to be careful to not be selective in what we choose to direct our outrage as a committee against, because one of my NDP colleagues had an axe thrown through his window from an Axe the Tax rally, right? That could be seen as a breach of his privilege, an intimidation of a sitting member to do his job properly. I think both instances need to be condemned, and we've, as a committee, have worked really well. I'm proud to be a member of this committee. Been proud to be a member of this committee for 6 years because of how well we work together. And we have dealt with some difficult subjects in the past. So I will be inclined to support this motion, but again, just with a cautionary note that we don't be selective in what we as a committee choose to investigate. This needs any chance that we get when there's been a breach of privilege. I think that's something that we as a committee have to be very vocal on. So I'll leave it at that, Chair.
Monsieur Parent.
Oui,
Well, this joins in with some of the comments made. Of course, on the substance, we're not against the principle that people have to be able to come and testify at the committee without fear of reprisal. That's clear. It's unacceptable for members of the committee to be intimidated as well. Parenthetically, also, Chair, perhaps we could enable the witnesses that are here who have finished their duties in that regard. The chair is not hearing me. The witnesses.
To our good officials, you have good work to do on behalf of Canadians. You are certainly released. I'm sorry if I didn't make that clear. That got moved, and I was focused on Mr. Barlow. So thank you to our witnesses on that side. Okay,
je
go
voulais
ahead,
dire
Mr.
au début de mon
I
intervention.
wanted to say at the start, but now I'm into the subject. So on the substance, it's a very serious matter, Chair. We cannot accept having people being bullied with regard to public information and defending their rights and interests, whoever they are. We're in a democratic society, and we, in fact, deplored certain deplorable incidents in the social networks before the holiday season. But, Chair, before we say that we're going to do a report and present it to the House, I would like the committee to examine what exactly happened. Were there any complaints or reports to the police? I was not aware of it at all. Now I'm being informed of it here. It's a motion that I was not given in advance. I agree with it being presented today, but we could have perhaps received it before the committee meeting. And as I say, with regard to the underlying principle, I think that no one can disagree with it. We need to protect our witnesses, but perhaps we could ask for information. Perhaps we could pronounce ourselves on it at a future occasion before we send it to the House. If we don't have the conclusive information, I think we need to work in a serious and conscientious manner. I appreciate the intent of the motion, and I consider it important. So I would like to step back a bit and get the information, and we can pronounce ourselves on it on a later occasion.
Here's how I read the motion, colleagues. It asks, first and foremost, for the clerk and the analyst to be instructed to prepare a report outlining the material facts of what Mr. Barlow has raised. I presume then, once that report and that analysis is contemplated, if there's a majority of this committee who wants to instruct me as the chair to find that there has been a breach of parliamentary privilege, then I would report back to the House. So I don't read this motion as an absolute breach right away, and that I would report back right away, because to your point, Mr. Parent, it first instructs the clerk and the analyst to prepare a report that then we would have to contemplate once that said report is done and when the information is pertinent to that. I am cognizant that this is an important discussion. I also know that there's other business we have to do. So I have Mr. Steinley, I have Mr. McGregor, and I have Ms. Taylor-Roy.
I would just say this, and I know that sometimes we want to expand the scope of some things, but we have specific evidence with the clerk and the analyst dealing with witnesses and conversations. So I think this can be something that is done relatively quickly. There is documented proof. They have had these conversations, and witnesses have put forward their concerns. There has been examples where they have gone to the RCMP, and quite a few of these are Indigenous women as well, Mr. Chair. Like, this is something that we need to take seriously. I would not want to see the scope expanded. There is documented proof with this specific bill. And I think we have a duty to make sure that people know that we're going to have their backs, like Mr. Barlow said. So I would not want to see this expanded. There are things on the table that we can, the clerk and the analyst can do their good work, bring a report, and we can look at it and see where we go from there. So I just worry that I wouldn't want to see growth in the scope. Like, this is something that we can look at very seriously and timely.
Yeah, I think it was just for the record that some of the colleagues were raising that. I mean, the motion is clear. But again, I want to make clear that the way I read the motion is that I'm not absolutely reporting back to the House. First and foremost, there has to be a contemplation of the brief that is submitted. Go ahead, Mr. McGregor.
Chair, I disagree with your reading because I think the motion actually does instruct you to report it to the House. And I want to follow on Monsieur Perron's suggestion. I do believe it would be prudent for us as a committee to review this. So I would suggest an amendment to this motion. I would suggest that in the first line that the clerk and analyst be instructed to prepare a brief report for the committee and then continuing on. And I would then, the next part of my amendment would be to delete and that the chair be instructed to present this report to the House forthwith. I think we as a committee need to be presented with this analysis and evidence first, and we can make a subsequent motion based on our review of those facts.
I've got Mr. Joanne and then Ms. Taylor-Roy.
To that point, if we are to eventually perhaps report back to the House, then obviously if the folks who have made these statements to our clerk, then I am interested in how do we protect them as well, because if we report publicly, we need to have a conversation about protecting those individuals that have made those particular statements. So I would be in line to supporting what Mr. McGregor said, and then maybe we can have a longer term conversation in terms of if we are to report back to the House, how do we do that and how do we protect the identity of those that made those statements?
Okay, we're happy to contemplate that. So we do have the amendment as moved. So we're on that. Ms. Taylor-Roy, any quick?
Yes, and thank you. I think, Mr. Chair, this is a very serious issue, obviously, and we want to be sure witnesses feel free to come and speak and testify. I think there are ways to protect witnesses in camera and doing other things already, but certainly if they have received threats. I'm curious, though, is this study specific to this bill, or will it also include other bills where we feel people have been harassed or bullied, such as perhaps 234?
The motion from Mr. Barlow as presented right now contemplates parliamentary privilege in relation to C-355. And the amendment that Mr. McGregor has made is that the analysts and the clerks will prepare a report with the pertinent facts related to this particular study. And then, as Mr. McGregor has also moved, he has cut off the portion of the chair being instructed to present back to the House forthwith. That will become subsequent to the report being prepared.
I just think since it's such a serious issue that perhaps we could look at it on a broader basis, because I think we've seen evidence of bullying around other bills that we've considered as well, which we didn't study. So I'm wondering if we should perhaps expand it, especially if we're going to make a recommendation to the House around this, because I think we do want to protect witnesses and make sure that people aren't bullied.
Okay, so if you think, Ms. Taylor-Roy, that there's consensus in this committee to do that, you can move a sub-amendment to the amendment that Mr. McGregor has moved. I don't know if that's the case, but otherwise, where I'm at procedurally right now is that, assuming there's no more debate, what we would do is we would vote on Mr. McGregor's amendment, and then we would vote on, assuming it, depending on how that goes, then we would then vote on the main motion that has been brought by Mr. Barlow. I see Monsieur Perron's hand.
Oui, donc là, j'ai compris que
Yes, so I understood that the amendment from Ms. Taylor-Roy has not been introduced. Is that correct? Fine, because actually we're talking about 355 because we would have examples on that, but it's not restrictive. Perhaps just to reassure you, Ms. Taylor-Roy, I don't consider this as being restrictive. It's just that if we have concrete examples, we could take action based on that.
that it's in relation to Bill 355. But again, what I would suggest, and again, in the interest of time here, colleagues, what I would suggest is if we are of the view of letting the clerk and the analyst to prepare it, and we feel as though there had to be an expanded element, to your point, Ms. Taylor-Roy, down the line to say, okay, has there been other types of parliamentary privilege that have been breached at some point? This committee is well within its right to do so. But I will turn it over to you, and I am in the interest of trying to litigate this so we can move forward.
Yeah, thank you, Mr. Chair. I think that's a good point, and I agree, we have to have specific instances. But I'm just thinking the clerks and analysts may have heard from witnesses in other studies similar things. And if they have, I think that should be included, not just the one study. So if the clerks and analysts know of other instances where there have been either witnesses or members that have felt they've been bullied and that has been brought to their attention, then I think we could include that in the report. So I'd like to see it a broader kind of, perhaps just in this session, indications that the clerk, so if that's agreeable to you, Mr. McGregor, to make it as a sub-amendment to yours, I would just broaden this a little bit.
It might be a different amendment altogether because Mr. McGregor didn't contemplate in his amendment actually amending the scope of the report that we prepared for the analysts. But again, in the spirit of this committee, Ms. Taylor-Roy, either you can move an amendment once Mr. McGregor's element is concluded. You can actually move another amendment to this motion, or this committee, which generally works pretty well in consensus, can contemplate what is before. And once the clerks and analysts come back, if we feel as though it has to be widened, we are well within our right to go further on that. I don't want to take too much more time. Go ahead, Mr. Barlow.
I just feel I should comment since this is something I raised. And this is a result of information and personal anecdotes that we've been sharing with the clerk throughout this entire process. So I wasn't doing this to make this a fishing expedition for other issues. This was just something that I've been here for a long time. This is I wanted us to deal with something specifically that has happened at this committee. I certainly don't recall another instance where a study that we've been doing at this committee where we've seen this type of vitriol, and certainly I know all of us were getting emails from people and pictures and all those types of things. And I guess my worry is that if we don't make a statement here, this will continue to proliferate, and this will be the signal we're giving that this is okay. You can treat people like this and treat potential witnesses like this. And how are we supposed to invite witnesses to come here and testify when we do have sensitive topics to discuss? And certainly animal agriculture is going to be one that is not going to end. These witnesses who have very important expertise to share with us are not going to come here if they don't feel that their testimony is going to be safe, they're going to be anonymous, or if they're going to be opening themselves to public harassment and intimidation. And so that's really why I had this focused on this particular issue. At committee with 234 here, we did not have that type of response from people at all. So that's why I want this focused. And just to Mr. McGregor's proposal for amendment, I'm totally fine with having the report come to committee, but I still strongly believe that this should be reported to the House because I think it's quite clear with the information that I've presented to the clerk over the last several weeks that this is an issue that was clearly a breach of privilege. I don't want to make that judgment, I guess, before everyone has a chance to see it. But I'm totally supportive of saying the report comes to committee first, but I still believe that the report should be tabled in the House.
And we can litigate that once the report is actually contemplated by the committee. I have Monsieur Parent first, and then Monsieur Drouin.
Merci, Monsieur le Président. Ça va être
Thank
très
you,
bref.
Chair. It'll be brief. In fact, I agree with what Mr. Barlow said with respect to Ms. Taylor-Roy. I do not think we should broaden it because we're asking for a significant job on the part of the analyst and the clerk to go in and get that information. And we cannot ask them today to go back and look at previous studies and find out whether they kept any trail of that. Let's start with this. And it doesn't apply to the bill, but rather to the study that we've just done. So we should not take it negatively as regards the bill, but it's important if we have testimony that Mr. Barlow stated, they have some aspect. We didn't see that. So what makes us hesitate today is that we didn't see that. We want to see it before we send it to the House. So I propose collectively that we vote in the amendment by Mr. McGregor and that we adopt a motion and settle that.
Quickly, the amendment from Mr. McGregor, I'm flying blind, so I'm not comfortable with, because I haven't seen anything. So we have not seen anything except for you, for that particular side. So I'm happy to get a report here, but after, I want to make another vote whether or not we report this back to the House. So that's because I'm blind. I don't know what's, I don't know what's happened.
No, it was table dropped. I can reassure you, Mr. Drouin, that what Mr. McGregor is moving would allow the clerk and analyst to prepare a report of the relevant facts and information, and then the committee can then further determine whether or not there is a breach of parliamentary privilege. So I am going to, okay. Go ahead, Ms. Taylor.
Yes, again, I haven't seen the motion, the amended motion right now either, but my concern is that if this is a broader issue, I want to ensure that we do look at the broader issue if it's established here. I mean, part of the problem with this conversation is that apparently members opposite are privy to information that wasn't shared with us earlier. So we don't really know what they're talking about or the extent of these threats and allegations. So I'm fine to have a report, but I just want to ensure that if this is happening, and in fact, the clerks and analysts have heard from other witnesses similar kinds of concerns prior, or from other people that they've been bullied, that we do expand it to that. And I don't think we need to specify this bill in this motion in order to do that. So I think there's a real concern about witnesses being free to testify, but I don't like tying it to this particular bill because it puts a, it kind of makes it sound like this bill was the problem when there are many other bills where similar things have happened. So that's my objection.
So what I would say is, having sat as the chair of this committee for 2.5 years, there's never been another instance that I can contemplate that there was a witness who asked to not be identified. We take pretty seriously our role that if there is type of harassment or the chair of the committee nor can the clerk or the staff contemplate the World Wide Web and what goes on outside the four walls of this committee. So I think it was relatively it doesn't happen often in terms of witnesses wanting to speak without being identified. I take your point, Ms. Taylor-Roy. I don't know of any other instances, but I do want to allow us to ask the question about whether or not we want to move forward with Mr. McGregor's amendment. And I do want to make sure that nothing is going to be reported back to the House at this point if Mr. McGregor's amendment is ultimately done. Now, if you guys want, we can stop the clocks, we can go print this, and we can have it back if you feel it's necessary so that you have the opportunity to see the amendment. I'll look to Mr. Drouin. Is that necessary?
No, I'm fine with as is.
I don't think...
If the other side agrees with Mr. Barlow's amendment, then we're good to go. Yeah, Mr. McGregor's. Yeah.
Vote on it as amendment. Approve Alistair's amendment that the report comes back here before going to the House.
I don't want to send a report to the House where I don't have knowledge on it. So I want committee.
And then we'll vote a second time.
Okay, that's fine.
Yep.
That's fine.
I don't want to look. It is crystal clear to me as the chair. So if we are okay to move Mr. McGregor's amendment to what Mr. Barlow moved, what that would then precipitate, what that would mean is the clerk and the analyst will go do the work. We will contemplate this further down the road when they have the time to do it. If we feel there is enough information and evidence that is provided that you want me to report back to the House that we feel as though there's parliamentary privilege has been, because I don't have the ability to, that's to the Speaker. I'm not sensing any concern, and we will come back to your point, Ms. Taylor-Roy. If you want to amend the motion, you can do that today. But I'm not so sure that there is a majority that will support that. But there's nothing stopping us from contemplating that down the road when we hear, and we perhaps go in camera to hear the information. You can ask those same questions to the staff that advised me about whether or not there is more that should be done, and the scope of this should be widened. Go ahead, Mr. Kerr.
Yeah, I just want clarity, please, Mr. Chair, on something. Assuming for a moment we adopt Mr. McGregor's amendment. The clerk takes this away. A report is brought back. We hypothetically, as a committee, vote down whatever comes from that, the prospect of reporting it to the House. Okay, that's the context. So my question within that context is, would the contents of the report, even without a submission to the House, be publicly available? That's my first question. Number two, would it be available to the Senate committee? And if so, eligible to be discussed in the context of the bill when it gets to the Senate's consideration of it?
On the first question, Mr. Carr, no, it is up to the majority of the committee, so it would not be shared publicly. On the relation to the Senate, I don't know if I have that answer at this point.
I think that's an important question.
We'll have to do research and report.
Okay.
But again, a committee is a master of its own domain. What I would say, if we choose not to have any of that shared, I'm quite confident on the public piece. I don't know about the Senate procedure, so I don't want to speak on that. But generally, parliamentary committees are, with consensus, able to choose to do whatever the hell we want within reason. Go ahead, Ms. Taylor-Roy.
I think there's consensus that we move forward on what Mr. Barlow has put forward. I do not feel comfortable voting on this when I don't have it in front of me with the amendments and when we don't know how this material will be used. But I think we have consensus, so I suggest that if we want an official, if the Conservatives would like an official vote on this, that we wait until the next meeting. We have the amendment printed and put before us, and then I may make a sub-amendment at that point to it. But right now, I think if we want to just go ahead and proceed with this as there's consensus in the committee like we often do, then I think that's fine.
The motion has been distributed to everyone's personal account now. We could just move the motion on division if you're not comfortable in having a specified vote, Ms. Taylor-Roy. But I do think there's a consensus to move with what Mr. McGregor has proposed. Are we good? So on the amendment to Mr. McGregor's amendment, it's simply he has moved for the committee and has scrapped the part at the end, which is, and that the chair shall be instructed to present the report to the House forthwith. Mr. McGregor rightfully has, I think, identified the fact that he doesn't want to give the pretense that absolutely I'll report back without having had that report prepared and analyzed by this committee.
Mr. Chair, where was the amendment sent or the motion sent?
The motion was sent to everyone's personal email account. If you'd like to suspend, I can do so, and we can. Okay. Everyone should have it in their email account as of about a minute ago.
And do we also have Mr. McGregor's amendments to this, the amended version?
If you would like, we can suspend and we can make sure it gets translated and everything on that side.
Yeah, just the one quick question. The motion as is, it hasn't been modified yet with Mr. McGregor's amendment.
I'll make this very clear to all my colleagues. So I will read it out in English very slowly for everyone to understand. That the clerk and the analyst be instructed to prepare a brief report, and this is where it's amended, for the committee, outlining the material facts of the potential breach of privilege related to the reports of threats, harassment, and intimidation against, and efforts to deter the appearances of potential witnesses and witnesses in relation to the committee's study of Bill C-355, an act to prohibit the export by air of horses for slaughter and to make related amendments to certain acts. And then it is stopped there. And this is to Mr. Jouin's point. Mr. Barlow's original motion contemplated this passing right away and that the chair be instructed to present the report to the House forthwith. That has since been amended by Mr. McGregor that we will consider the report that has been prepared and then ultimately make the decision of whether or not you would instruct me to go to the House after that.
And I'll just note on that, that yesterday, whether we agreed or not, was a form of bullying on private citizens than what happened in the House of Commons. And I'm just, we're dealing with this today, but what happened yesterday, I wasn't in the House. I want no part of it because we have authorities that deal with this kind of stuff. So again, when we're going to have to rule on whether harassment was done or not, I'm going to have to, are we going to invite the HR expert or something to determine that?
So, Mr. Jouen, again, the committee, what the instruction is that the clerk and analyst will prepare a brief report outlining what is the facts and the material element of what is being alleged in the motion that is presented by Mr. Barlow. We will be free to ask questions. We will be free to bring other individuals as we see fit, because this committee is a master of its own domain. So that will be completely up to you and anyone else on this committee about how we want to handle what would then be subsequently prepared by the analysts. And whether or not we choose to find there is parliamentary privilege ultimately is not our, if we feel as though it has been reached based on the definition, you can then instruct me as the chair to go back to the House on that, or you cannot. That will be up to this committee to decide, including the parameters of how we determine that, which will be, I presume, an in-camera setting. Again, something that I do. So I want to deal with what's here. It seems as though there's a majority that agrees with the approach that has been proposed, and I don't want to spend too much more time because we are coming to a close, and I know, Mr. Lewis, you want to move something as well. So any further? Go ahead, Ms. Taylor.
Yes, I'll just repeat that I think this is a very important issue. I agree with you, Mr. Barlow, that witnesses should not be intimidated, and we don't want to see bullying at all. I think it is. I think the problem with this motion, though, is we have in here a potential breach of privilege. I don't think we've even established. You said that you thought the privilege of members of parliament extended to witnesses. It wasn't very clear on how it does. But I think there's a lot of things around this, and what are the repetitive threats, harassment, and intimidation? Again, how are we defining those? What do we think those are? I mean, I'm all for doing some kind of a investigation into this. I don't know it's committee business, and I don't know it should be related to the study of Bill C-355. I think it should be broader if this is happening. And when you asked to have, or when the witness asked to come to committee and have their identity protected, we were told that this had been done in other committees before, that this type of procedure. So certainly there are other examples in other committees of instances where people felt that they needed to be protected before coming to witness. And there is the ability to appear in camera that is provided, and I'm presuming that is also because of those same considerations of privacy or perhaps fear of intimidation. So I feel that this is an attempt to link this to Bill C-355 in particular, and I don't believe it is an issue that is only specific to Bill C-355. And I think that this has the potential to undermine in some ways the bill. If you'd like to remove, the reference to Bill C-355 and make this broader, which I think addresses your concerns, I'm more than willing to do that. I just do not want to see this in any way targeting this specific bill.
Colleagues, I do want to move. I take the points that have been raised. Ultimately, pending there being another sub-amendment to what Mr. McGregor has moved, I would like to call the question on whether or not, and if we need a vote, we can, and if people need more time to contemplate it, I can work to suspend, but otherwise I would like to just call the question. To your point, Ms. Taylor-Roy, if we go down this study, which Mr. McGregor's amended motion would contemplate, if we feel as though there is other instances, we are well within our right to report back in a way that includes those elements that you said. So, I don't. Do you want to suspend? Not necessarily. I'm going to go to Mr. Liu. If you guys want to continue to consult, go ahead.
Merci, Monsieur le Président. Je pense qu'on a fait le
Thank
tour
you,
de la
Chair. I think we've covered the issue
motion amendée de
with the amended motion from Mr. McGregor. I would ask that we vote.
I think it was a deleterious motion, correct? So I think we have to go to, I think you just moved a motion to go directly to a vote. Ms. Taylor-Roy, I'm going to give you just a few minutes to get back to your seat so that we can allow for the vote to be called. Ms. Taylor-Roy, I'll have to, there has been a motion moved. I have limits in how long I can delay that for a vote. So I will repeat it, yes, just, yeah. So colleagues, there will be a vote, and it is on the amended motion from Mr. Barlow, that the clerk and analyst be instructed to prepare a brief report for the committee outlining the material facts of the potential breach of privilege related to the reports of threats, harassment, and intimidation against, and efforts to deter the appearances of potential witnesses and witnesses in relation to the committee study of Bill C-355, an act to prohibit the export by air of horses for slaughter and to make related amendments to certain acts, period. I'll call the vote. Yes.
Monsieur Drouin.
As amended, right?
This is on Mr. McGregor.
Okay, en faveur, en faveur.
Monsieur Carr.
Yes.
Monsieur Lewis.
Yes.
Monsieur McDonald.
In favor.
Madame Taylor-Roy.
I just want to be clear, this is on the amendment, correct? Yes.
Monsieur Barlow.
Yep.
Monsieur Lehoux.
Oui.
Madame Rood.
Yes.
Monsieur Stanley.
Yes.
Monsieur Perron. Monsieur McGregor.
Yes.
Okay, colleagues, so that's unanimous. So now the motion by Mr. Barlow is adopted, or is amended with Mr. McGregor's element. So now technically, assuming we need it, I can call the vote on the main motion. Assuming no other debate, I'm going to call the vote on the main motion.
En faveur,
Monsieur Drouin.
En favor.
en faveur.
Monsieur Carr.
Favor.
Monsieur Lewis.
Yes.
Monsieur McDonald.
Oui.
Madame Taylor-Roy.
Against.
Monsieur Barlow.
Favor.
Monsieur Lehoux.
Oui.
Madame Rood.
Yes.
Monsieur Stanley.
Yes.
Monsieur Perron.
Oui.
Monsieur McGregor.
Yes.
Okay. Obviously, colleagues, that passes. Mr. Lewis, you have the floor very quickly.
Thank you, Chair. I want to thank everyone. And yes, this committee does work well together. And I put a notice of motion the other day. I hope everyone got it. So I'd like to table that motion. It's about protecting farmland. And I think this is the perfect spot to do that. Many of our members are here from Ontario. And we know that in Ontario, we're losing about 319 acres of farm every day. And only about 5% of Ontario's landmass is suitable for agriculture. So my riding, Kitchener-Conestoga, is at the heart of Ontario's agricultural land, and we're facing farmland loss right now. So as Canada grows, we have to do things and do so while protecting prime agricultural land. So I believe that all levels of government can collaborate in a nonpartisan manner to preserve farmland for today and for future generations. So I'm going to table this motion that says, pursuant to Standing Order 1082, the committee undertake a study on the protection of prime agricultural areas for their long-term agricultural use, the use and/or development of agricultural land as defined by Canada Land Inventory for non-agricultural development, and that no fewer than 4 meetings are set aside to hear from witnesses, that the committee report its findings to the House, and that pursuant to Standing Order 109, the government table a comprehensive response to this report. So in the interest of time, perhaps we can talk about the details of how many meetings and when that happens in a subcommittee, but I thought it was important to table this now.
Yeah, we are getting tight on time. And by the way, we didn't have the opportunity to say congratulations. The bill did pass in your name. We moved to a point of privilege. But I hear you moving it, but you are okay for us to wait another day to determine whether or not we want to move forward. Mr. Perron, I saw your hand, but perhaps where Mr. Lewis is willing to engage on this topic in another day, we can go. Go ahead.
Oui, c'est une bonne chose. C'est ce que
Yes,
j'allais-
it's a good thing. That's what I was going to ask to do another day because farmland protection is essential. However, it's 100% under provincial jurisdiction and under Quebec's jurisdiction. So your motion today, if you vote, I would have to vote against it. I invite you to consult the members of the committee and to look into it if you can find some formulation that could be acceptable. But in that topic, it will not be easy for us.
Go ahead, Mr. McGregor, and then we're going to let people Go to question period.
Yeah, similarly, I think the idea has merit. I would vote to adjourn the debate on this because I need more time to contemplate it. But in British Columbia, we have the Agricultural Land Reserve. Like, I don't know of any opportunity where the federal government can get involved in the province of BC. That is entirely under the province to protect. It's under legislation, has been since the 1970s. So I think it's a good idea, but I think there's a number of motions that are on notice right now, and ultimately, Chair, I think we need to have a subcommittee meeting to try and do some air traffic control on this. So, thank you.
Okay, colleagues, we will do that. And as you know, now that we have finished 355 on the clause by clause, my intention, as you instructed the other day in camera, is to move to the contemplation and the finishing when we come back from the break week on the study on food price stabilization. So that will be the Tuesday. We will get that report done. I will be happily work with my vice chair, my two vice chairs, and Mr. McGregor and Mr. Drouin